Mr. Inbavijayan sir to deliver his lecture. Before that, I want to introduce him. I'm very much happy to introduce him before this forum. So he's an eminent in handling legal disputes as an advocate, arbitrator, and mediator. He has been accredited as an arbitrator both in domestic and international arbitration institutions. He currently holds a wide range of posts such as managing partner, foreign director, arbitration coordinator, honorary legal consultant, founder, technical assistant, advisor, visiting professor, chairman, and fellow and member of various international institutions. He is also a recipient of various awards for his outstanding performance as an arbitrator at international level. He is not only eminent but also enthusiastic towards the promotion of ADR that made him to write many books and articles. He doesn't stop with that. He also gives lecture in universities, Chamber of Commerce, and in conferences at worldwide. I wish your efforts must continue in future as well, sir. I conclude with this due to time constraint. With very few details of him, I invite Mr. Inbavijayan sir to deliver a lecture on influence of dispute resolution clause in arbitration. I leave the forum to you, sir.
Thank you, Assistant Professor Madhumita. First of all, it's a great honor. Like Honorable Justice was happy to share his alma mater. I also happened, but I was in the later stage in the 5-year integrated course at Dr. Ambedkar Government Law College. Further to add, I like to thank Principal Ma'am, Dr. Gauri Ramesh, Dr. Santosh Kumar, the Director of Legal Studies, Mr. Gopi Ravi Kumar, the Law Secretary, Government of Tamil Nadu, and the co-speakers. Most importantly, the session very well moderated. I'm happy here to just share a few words about the dispute resolution clauses in arbitration. What is a dispute resolution clause? I think many would be quite somewhat in a hypothetical situation. What might be a DR clause? We are speaking about ADR, that is the alternate or alternative dispute resolution. At this point of time, what we are going to deal with dispute resolution clause. It's very simple. In a contract or an agreement, when a party wants to find a forum, that is the forum shopping, we have the best option to incorporate a dispute resolution clause. Traditionally, we have a concept called the court jurisdiction clause. That is the acceptable dispute resolution clause we commonly come across. But now we are in the hybrid level of management of the disputes. The best option is go for alternate dispute resolution clause. When it comes to alternate dispute resolution clause, first of all, we have to understand what the advantages in it. Why we go for a dispute resolution clause, particularly an alternate dispute resolution clause. Kritika, can you move on to the next slide?
Sir, Shyam sir is operating the PPT, sir.
Okay, yeah.
He will be guiding you, sir.
Yeah, please. Shyam, we can just
yes,
go to
yes, sir. This one, sir. This one is fine.
You can make it a full screen, sir.
Full screen,
it's already full screen only, ma'am.
Slideshow, yeah.
It's a slideshow, yes.
Yeah. Okay, fine.
This one, sir.
Yeah, next one. Thank you.
This one, previous, sir.
Yeah, fine.
Fine.
The dispute resolution, when it comes to arbitration, it has been taken up because of 5 important things. One, it is the flexibility what we have when it comes to arbitration. Second one, the cost effectiveness, the reasonable cost when it comes to, at least in a domestic arbitration, not in an international arbitration. Thirdly, the confidentiality in that process. Fourthly, the fairness in that process. And finally, the finality in that process. Whether it is going to be the flexibility in the procedure, whether it's going to be the cost effectiveness, whether it is going to be the confidentiality, whether it is going to be the fairness, and whether it is going to see the finality. All these combined together push us a party to go to arbitration. When they want to go to arbitration, these 5 ingredients are very much required. All these 5 ingredients is very well available when it comes to arbitration. That is why the best dispute resolution clause is adopt an arbitration clause. When we are going to adopt an arbitration clause, 2 other things also we have to just consider the advantageous situation. One is the dispute resolver nominating or nominated by the disputants, as well as the dispute resolver also fix up the procedure. All these combined together makes the parties go to arbitration, starting from flexibility, having with finality, and finally ending up with the guiding process of the procedure. With all these, in the present scenario, as rightly Honorable Judge was mentioning about the reforms happened in the arbitration in 2015 and 2019. Now, this dispute resolution mechanism has been considered as a primary form of dispute resolution. This primary form of dispute resolution now has got 4 very interesting acceptance ratio. One is it is authorized. Next, it is authenticated. Further, it is approved. And finally, it is accepted. It is authorized by the reforms what happened from 1996 based on the unsettled model law on international commercial arbitration 1985. It got authenticated by various apex court judgment as well as the high court judgments. It got approved the way how it has been taken by various stakeholders. And finally, it is being accepted because the parties choose this. All these components what we have just gone through, from flexibility to the extent of the acceptance, makes us to go to arbitration. Having said that, in my actual presentation, I think there is some issue in the slideshow. In the 3rd slide, we can see a small picture wherein the elephants are given. I feel that whether it is going to be an Indian elephant or a Thai elephant or an African elephant, all these resemblance the arbitration. Arbitration is considered to be elephant. This elephant is going to be effectively delivering its goods when it comes to dispute resolution clause, a properly drafted dispute resolution clause. In the 2019 or even the earlier forms, that is the 2015 and the principal form of 1996, we can't just literally see how a dispute resolution clause has to be drafted. Similar to how an award has to be drafted, the law is quite not lucid clear when it comes to how to draft an arbitration clause. If the law is silent on how to draft an arbitration clause, how we can take this? How a dispute resolution clause should be structured? We have to keep in mind, very interestingly, 5 components. The 5 components what a dispute resolution or an arbitration clause should possess. 1, the number of arbitrators. How many arbitrators are going to deal with the dispute? Next, what is going to be the applicable law, the procedural law for that arbitration? Thirdly, we have to just consider what is the language. Then, as the judge was highlighting about the component of place, place has to be rightly mentioned. And finally, it has to be mentioned what nature of dispute has to be referred to arbitration. A dispute resolution clause would be wholesome when it has all these 5 components. The number, how many arbitrators are going to deal with the arbitration. Very interestingly, one judgment he was mentioning that in a 3-member tribunal, the dissenting opinion, that is in 2:1, the one.
Sorry to interrupt, Inbavijayan sir.
Yeah.
We are having a lot of technical issues.
Okay.
So once you want to move the slide, please inform us. We will move.
Sure. You can
The weather is very bad out here. We are very sorry.
Okay. Okay, okay. You can move to the next slide.
Yes, sir. Is it fine, sir?
Next.
This slide, sir. Okay. Yes, sir.
Next. Yeah, this one. Dispute resolution arbiter. You can go back. You can go back.
Okay, sir. Yes, sir. This one, sir.
This
Yes.
one.
Thank you, sir. Thank you. I will have a follow-up henceforth.
Yeah, yeah, fine. If you see these caption given about the dispute resolution clauses, the number is very important. Assuming that a dispute resolution clause is silent on the number of arbitrators, and getting back to the example, Sangyong, what the judge was mentioning about the arbiter tribunal, one arbitrator's decision was upheld, and the award given is a 2:1 was set aside. The number of arbitrators, normally it is the best practice to have a single arbitrator. If a clause says that we need to have 3 arbitrators, how the 3 is going to be appointed, the law guides. No doubt the law has the system how to appoint all the 3 arbitrators. But here, a very, very tricky component comes. What might be the qualification for all these 3 arbitrators? It's a highly influential part in the dispute resolution clause when it comes to arbitration. Invariably, in most of the arbitrations, we'll have all the 3 persons with legal knowledge. There is an ideal team of arbiter tribunal, but it is not say in all the cases. There might be a dispute with highly a different domain. A technical expert might be required to deal with that arbitration. But the dispute resolution clause would simply mention 3-member tribunal. With 3-member tribunal, without mentioning of the qualification, how the parties or the disputants is going to go to the next level, how to manage, how to even commence the arbitration, how to constitute the arbiter tribunal. A simple answer is that go to the courts, particularly the High Court would appoint the arbitrators when it comes to domestic. When it goes for the international arbitration, we can go to the Supreme Court of India. But this actual influence of the arbitration process can be effectively dealt. And that has been facilitated in the second reform of the arbitration legislation, that is in 2019. Very interestingly, there is an 8th schedule brought in by the amendment in 2019, wherein a separate head for qualification and experience of an person to be considered as an arbitrator or to be nominated an arbitrator has been incorporated. What extent such an interesting reform would facilitate an effective dispute resolution clause in an arbitration? As a litigant, we all can literally take the consideration of the recommendation given in that 8th schedule, and we can incorporate a constructive qualified person to act as an arbitrator in addition to the numbers. The numbers seriously matters. In additionally, you can also bring in qualifications. The 3-member tribunal should have a qualification with legal knowledge, with technical expertise, with reasonable number of past experience in arbitration as well as in the domain. In such a way, this aspect of the number of arbitrators with qualification can facilitate an effective arbitration. Next, the multi-tier approach in a dispute resolution clause. The bottom it's given. What is a multi-tier approach? We are not inclined to file a civil suit. That is why we are going for a dispute resolution or an arbitration clause. In an arbitration clause, coming to the primary form of dispute resolution arbitration, there are other options. If you are going to include in a dispute resolution clause the other options like mediation, conciliation, the dispute review boards, all these are considered to be a multi-tier approach in a dispute resolution or arbitration clause. The only rider what we need to have is that include a multi-tier approach, but in a multi-tier approach you also include a time frame. If you want to have a mediation included in a dispute resolution clause, even before commencing an arbitration, have a time frame. 30 days, 60 days. Mediation, if it effectively concludes within that 60 days, then the parties can end up resolving the dispute, having a settlement agreement which is mutually acceptable and enforceable. If the mediation is unsuccessful, then the parties have to take it to the next tier. Next tier is going to be arbitration, have a time frame, a 60 days time frame or a 90 days time frame. Very interestingly, when we are dealing with a dispute resolution clause, dealing with parties from Far East, they won't mention about the time. There is no time frame like 30 days, 60 days, 90 days. How long the mediation goes and where is the end for the mediation? Because mediation can be effected within a day, within an hour, or it can even go for more than a year. There is no time restriction when it comes to dispute dealing by mediation. Anyway, we are going to have a mediation law in near future once this UNISA convention is going to be adopted and ratified by Government of India. Until that time, we don't have a time frame for mediation. Better as a parties in the dispute resolution clause have a time frame 40 days, 30 days, 60 days or 90 days. Coming to the aspect of the place. In my limited experience in arbitration, the highly influential factor in a clause considering an arbitration is the place. If you have the term arbitration and if you mention a place in an arbitration, that is sufficient to have a highly influential arbitration to be invoked, to be effectuated, as well as to conclude. A dispute resolution clause should have a proper mentioning of the place when it comes to domestic, and when it comes to international, it is better use the juridical seat. The place determines and facilitates the procedural law applicable to the particular process. The place provide the interpretation as well as the intervention of the courts, particularly from that jurisdiction. If you are not mentioning the place, assuming that two parties coming from India having an arbitration clause and they want to start an arbitration without the clause mentioning any place, where to start, where to continue, where to conclude, and which court has the jurisdiction, how to proceed, nothing. Nothing is mentioned. Place, if the place is not mentioned categorically, or if the place is not agreed by the parties in the dispute resolution clause, then we have to just ultimately depend on the courts to guide us. But here also comes a question, which court, which national courts to approach? Be clear, the dispute resolution clause would highly be influenced in an arbitration process, particularly on mentioning and non-mentioning of the place of arbitration. Language is a supplement one, and the procedure law follows when the place is being clearly mentioned in it. This simple flow chart, what has been given in this slide, helps you out in all the aspects for highly influencing the arbitration process. Can you move on to the next slide?
Yes, sir.
You can just skip to a couple of slides. Next.
Okay.
Next.
This one, sir? Okay.
Next. Yeah, fine.
Yes.
The other interesting point, what I wanted to help and to share with all of you is that the significance, very interesting significance of this dispute resolution clause, particularly in arbitration. When you look into the model law, when our law secretary was mentioning about the historical background of the arbitration legislation of 1996, the ancestral model law. When you look on Article 16, which is also repeated in Section 16 of the Arbitration Conciliation Act, the wordings are very clear. For the purpose of determining jurisdiction an arbitration clause or a dispute resolution clause which forms part of a contract shall be treated as an agreement independent of the other terms of contract. The arbitration agreement is not affected if the main contract is void, terminated, illegal, so forth. Very, very, very interesting background of this particular doctrine of severability. The arbitration clause or a dispute resolution clause sustains even if the contract is declared null and void or terminated or declared illegal. To determine that itself, we need to invoke this dispute resolution clause. Very, very acceptable, very much usable for the litigants when it comes to arbitration. This can be effectively invoked when we have a proper dispute resolution clause. Next, please. Okay. The final part of my small presentation on this influence of dispute resolution clause in arbitration now is the era of institutional or administered arbitration. We are not happy with ad hoc arbitrations, and our dispute resolution clause also have to go with institutional arbitration clauses. That means it is not going to be in the hands of the arbitrators. It is not going to be in the hands of totally on the parties or the disputants of the particular process. This particular process is now going to be facilitated by institution, not judiciary, but it is an institution which is going to be independent institution, which institution is going to be graded by the Arbitration Council of India out of the 2019 amendments in the Arbitration Act. The 2019 amendment wants the arbitration to be administered by institutions, and that institutions or those institutions which are going to be doing or effectuating this particular arbitration role are going to be graded by Arbitration Council of India, and the institutions are going to recommend the arbitration clause. Now we got a solution. The dispute resolution clause, the way how it's going to influence the arbitration now, it's very, very clear. It is going to be on the path of institutional arbitration. If it is going to be on the path of institutional arbitration, we need not worry. All institutions in existence as well as which are going to come in future in India and outside India suggest model dispute resolution clauses. If those model dispute resolution clauses are adopted in total, then we have no issue in arbitration at all, no negative impact at least. The positive impact is that the institutions would eventually accept those cases, they take it in their registry, they appoint the arbitrator, they conduct the arbitration proceedings, they also facilitate even the scrutiny of an arbitral award. The Secretariat would scrutiny not into the core issues but on the procedural aspect, and finally the institution would be an effective depository for that arbitration. The highly influential dispute resolution clause in an arbitration in this present scenario would be just a model institutional arbitration clause. For example, in India, we have a very old institution which was created in 1965, that is the Indian Council of Arbitration. You can just Google and get their model arbitration clause. If you adopt that clause, that is sufficient. That itself would deal with the entire arbitration process. We need not worry. But the only thing is that we should not tinker it. We should not have an adventure on that clause. We should simply adopt that clause, and in that way, the arbitration would be effectively commenced, continued, and would deliver a enforceable arbitral award. Can you move on to the next slide, please?
Yes, sir.
Next slide, please. Yeah, some common errors before going into the last slide. As I earlier mentioned, non-specifying the place would create a problem in arbitration. Erroneous names of institution. Just now I said that institutions like Indian Council of Arbitration can just mention and put their clause. Instead of mentioning Indian Council of Arbitration, if you are going to mention India Center for Arbitration, it is not an institution as such. We have only an institution called Indian Council of Arbitration. We don't have a institution called India Center for Arbitration. This is a common error which would lead to an ineffective arbitration process. Tinkering with model clauses. If you have an institution clause, literally adopt that model clause. Don't ever try to change. And finally, poorly drafted tiered clauses. All these I find is a common errors when it comes to ineffective dispute resolution clauses, particularly in arbitration. Can you move on to the next slide? Yeah. Out of the research, what for the past 2 decades, what I had when it comes to dispute resolution clauses, I think a honorable judge also would accept, because some 13 years back in the month of September 2007, he delivered a lecture for our institution, early institution where I was a founder member. He gave this very interesting point, the first point. An arbitration prevails over court jurisdiction if you have an effective dispute resolution clause. I literally learned the very significance of Section 8 of the Arbitration Conciliation Act, which gives the immense power for the arbitral tribunal and which even prevails over the court jurisdiction. The very ideology of party autonomy choosing for such a dispute resolution clause is the actual influence in an arbitration. Secondly, the disputants choose predominates in the arbitration process. The arbitration process is predominantly the choice of the disputants. Thirdly, there's a high possibility and prospect of amicable settlement of dispute. Ultimately, we all, whether it's the judiciary or whether it's the arbitrators, whether it is the mediation or any process, ultimately the dispute has to be resolved. We are all there to manage the dispute. Particularly, an amicable settlement of a dispute has to be the welcome note of any disputants. And the most important thing for a disputant is that their dispute should be effectively managed. That is, an effective conflict management with fairness and reasonableness is the actual influence of dispute resolution clause in arbitration. Thank you. Thank you for this opportunity.
Thank you, sir. Thank you very much for your wonderful lecture, sir. Sir, actually, we have so many questions, sir. Due to time constraint, I had to pick only one question, sir. Questions are more or less similar. I just want to say the questioners, KSK Bharati, Vimala Rajagopal, Kalima Khan, Vijay Kumar, and Sudhir Chandran, sir. They are asking whether the whole proceeding of arbitration can be held and concluded via video conferencing itself, and whether virtual arbitration award is possible for implementation under CPC, that too in case of international commercial arbitration.
Fine. Taking the first question, if the entire arbitration proceeding is going to be virtual, whether it is first of all acceptable, at least in my perspective, my presentation, in the earlier slides, whether you can just look into, have I just mentioned about any virtual hearing? No. It is all left to the parties to agree. If the parties have agreed, mutually agreed that the hearing can be conducted in a virtual manner, fine. There is no impediments. It is an acceptable process and it be finally enforced. There is no issue on it. But now, this situation is totally unexpected. We didn't anticipate such a situation. Now, how to take it forward? As earlier speaker, Dr. Natali was mentioning, there are some protocols and guidelines for virtual hearings. If the parties wants to have this virtual hearing in total, opt for from some assistance of an arbitration institution. Those institutions have these protocols and guidelines, and most interestingly, one is the disturbance in any arbitration, the examination of witnesses. The only problem is how to monitor the witness, whether the witnesses are coached, whether any coaching is happening. Very simple answer is given by all these institutions that the participants, all the participants, including the witnesses, should have a camera which is 360 degrees. That is the only answer.
Sir. Thank you, sir, for your answers. You have answered very patiently. Thank you, sir. Over to Hepzibah, ma'am.
Thank you so much, sir. It was pleasure listening to you as always. Now I request Advocate Anirudh Krishnan, followed by Professor Dr. Samia Tabasam, to share their thoughts on the topic they have chosen. I request Mr. V. Shyam Sundar, Assistant Professor, Chennai Dr. Ambedkar Government Law College, Pudupakkam, to moderate the session. Over to you, sir.
Thank you, madam. Yeah, I'm happy and privileged to introduce our fifth speaker, Mr. Anirudh Krishnan, advocate, founder, partner of AK Law Chambers in this forum, who is very much familiar in Madras High Court. He completed his LLB course in Nalsar, Hyderabad, and Bachelor of Civil Law from University of Oxford in UK. He is qualified solicitor of England and Wales and appointed as an expert of law in International Chamber of Commerce in London. He is a member of more arbitration committees in India and steering committee member of Italian Chamber of Commerce. He is appointed as a consultant by a Law Commission of India for the report of arbitration and appointed as special committee member by Honorable Chief Justice of Tamil Nadu for setup in a PL to suggest reforms to certain backward regions in the state of Tamil Nadu. He is the author of many books, articles, and journal write-ups. Our college is personally thankful to him for being the draftsman for the moot court problem for the national level moot court competition conducted in the year 2010. I hereby hand over the virtual forum to Mr. Anirudh Krishnan to deliver a speech on India as a seat of arbitration. Please, sir.
Thank you. Thank you, Professor Shyam Sundar. I would also like to thank Professor Dr. Rekha and Professor Dr. Gauri for having invited me, as well as also like to thank the institution, Ambedkar Law College, for inviting me to be part of this wonderful panel discussion. Thank you very much. Now, the topic that I'm going to be speaking about is India as a seat of arbitration. So the way I'm going to look at this is, what should an ideal seat of arbitration contain? What should it provide for? And in each of these ends, you're looking at each of these as criteria that I mentioned as ends. Where is India today? Therefore, for a particular country to develop as a hub of arbitration, to be a leading seat of arbitration, like England or Singapore, in my view, there are 4 important criteria that one needs to look at. The first is the robustness of the regime itself. That is, what is the quality of the regime, which is ultimately reflected in the quality of awards. Because when you talk about arbitration, on one hand, you're talking about party autonomy. You're looking at an alternative dispute resolution, something alternative to court. Yet on the other hand, when looked at from a different perspective, you're outsourcing commercial dispute resolution, which means that you have a private arbitrator chosen by the parties interpreting the law of the land and coming up with an award. Therefore, courts need to ensure that this award is in consonance with the law of the land. Right? Therefore, on one hand, you need the regime to be excellent where most awards are perfect. And this would lead to the second factor, namely minimum judicial interference, something that Honorable Justice Sundar spoke about at length. So the first criteria is quality of the system itself. The second criteria is the concept of minimum judicial interference. The third, in my view, is to create a system that incentivizes compliance. And the fourth, in my view, is having a culture of arbitration where arbitrations are conducted professionally and in a very efficient manner. These are the four ends that ultimately need to be met for a country to develop into a good seat of arbitration. I will take each of these four heads and discuss where we are when we look at India's progress towards the seat of arbitration. Right? Let me start off with the first, namely the quality of the regime itself. When you talk about the quality of the regime, the first thing that comes to mind is whether or not the regime is a neutral regime. If you have a regime where arbitrators are biased and you're fighting for neutrality, then the regime can never be a successful regime. In India, for a number of years, we had a major problem because of one judgment in Indian Oil versus Raja Transport, where the Honorable Supreme Court held that even if an employee of a public sector undertaking acts as an arbitrator in an arbitration involving that public sector undertaking, there would be no presumption of bias. There were a number of judgments after that where the Supreme Court tried to carve out exceptions from the rule. But the result of this judgment was that at least till 2015, neutrality was a huge question mark, because in every public sector undertaking arbitration, you would have an employee of the same public sector undertaking sitting as an arbitrator, because the Supreme Court had said that this was justified. In 2015, based on the Law Commission recommendations, Indian Oil versus Raja Transport stood legislatively overruled. The amendments brought in the 5th and 7th schedules, which are based on the International Bar Association guidelines on neutrality. Therefore, there are certain guidelines, there are certain relationships between the arbitrator and the parties, between the arbitrator and the counsel, between the arbitrator and the dispute itself, that are listed in the 5th and 7th schedule. The 7th schedule corresponds with what is called as the red list in the IBA guidelines. The 5th schedule includes both the red and orange lists of the IBA guidelines. If an arbitrator falls, if an arbitrator's relationship with either the party, the counsel, or the dispute itself falls within the ambit of the 7th schedule, the arbitrator is barred from acting unless parties consent after the dispute has arisen to have the said arbitrator decide the issue. If the arbitrator's relationship falls within the 5th schedule, then there is a presumption of bias. This greatly improved the position from where it was prior to 2015. However, there are still some roadblocks along the way. There have been a number of judgments interpreting the 5th and 7th schedule. A few have been extremely progressive, and a few may need to look at this from a broader perspective. So one of the initial judgments was that in HRD, where the Honorable Supreme Court very clearly stated that if the relationship of the arbitrator falls within the ambit of the 7th schedule, you have a right to directly proceed and approach court under Section 14 for termination of mandate of the arbitrator, since the arbitrator would be de jure incapable of performing his duties. The rationale is that the arbitrator is prohibited from acting by virtue of the 7th schedule, and hence the de jure incapability follows. This was a very progressive judgment, because the popular view was that in cases of bias, you will have to raise the issue before the tribunal, wait for the tribunal to make a finding, and then challenge it under 34, by which time a lot of damage can already be done. But please keep in mind that this exception in HRD is only if the arbitrator's relationship falls within the ambit of the 7th schedule. Not if it falls within the ambit of the 5th schedule, in which case a party must approach the arbitrator and raise the issue before the arbitral tribunal. You've had a number of other judgments. You've had the judgment in West Alpine's case, where the Supreme Court said that ideally, where a panel is nominated by one of the parties, from which the other party must also select, the panel must be a broad-based panel, 30 to 40 arbitrators. So therefore, the other party does have a wide choice. This has subsequently been diluted by a judgment in central electrification, which in my view is problematic when one looks at the neutrality regime. Based on central electrification, if a party nominates a panel of 4 arbitrators, like in the railways general conditions of contract, and the other party can only choose its arbitrator from within these 4, such a clause is valid, as the party in fact has choice in the matter, because they can still select one of the 4. This is problematic. This is by a 3-judge bench of the Supreme Court, which considered 2 earlier decisions in Perkins and TRF and distinguished them, because in Perkins it was held, and I think Perkins is one of the most progressive judgments of recent times in the field of arbitration. In Perkins, the Honorable Supreme Court held that unilateral appointment of an arbitrator by a party is not permissible. The rationale is that the other party does not have a choice of appointment in the matter, and the Supreme Court relied upon an earlier judgment of the Supreme Court in TRF's case, where it was held that if you are ineligible to act as an arbitrator, you are also ineligible to appoint an arbitrator unilaterally. Right? Therefore, today the position that emerges is that unilateral appointment of an arbitrator is not valid, is not permissible based on TRF and Perkins, but unilateral selection of a panel of 4 arbitrators from which the other party must choose its nominee has been held to be valid pursuant to central electrification, and that I think requires a relook, with great respect to the Honorable Supreme Court, because when you look at matters of neutrality, it's always easier to err on the side of caution and ensure that you have a regime that ensures neutrality of arbitrators. And therefore, where are we? We have certainly come far from the Indian Oil versus Raja Transport regime, but there are still some problems that we need to relook at. I also feel maybe we require a small tweaking of the 7th schedule, because what works internationally is not working perfectly in India, right? So when you go by a strict interpretation of the 7th schedule, an ex-employee would not be covered in one of the relationships set out in the 7th schedule. Maybe we need to amend the 7th schedule to make the language wide enough to cover ex-employees as well, because a lot of PSUs resort to appointing ex-employees who seem to know all the witnesses, who seem to know all the officers involved in the project, and that again creates a regime that is not neutral. Right? So therefore, certainly there have been positive steps taken, but there could be a few more amendments that could be made to the 7th schedule that could help further improve the situation. The second subset is of quality, of having a robust arbitration regime, is efficiency and quality of the system itself, which is driven by the efficiency and the quality of the arbitrator and the infrastructure available to the arbitrator. Now in India, I think we have a huge demand-supply issue, because when you look at the number of arbitrations and compare this with the number of good, honest arbitrators, there are far more arbitrations than arbitrators. Right? So how do we improve this? I'm not saying that don't mistake me saying that we have a dearth of good arbitrators. That is certainly not what I'm suggesting. We have some arbitrators who are of world quality, who are of world class in their approach. But the problem is that you have so many disputes that each arbitrator is overburdened with 30 to 40. Any good arbitrator that you meet would have at least 20 cases going on simultaneously. And where each case goes on for multiple hearings, this becomes a volume, this becomes quite difficult to handle. So one way could be to widen your pool of arbitrators. Have more subject experts. You have shipping experts, you have engineers. Have more subject experts sitting as arbitrators. Have more senior counsels and lawyers sitting as arbitrators. So widen the pool so the arbitrations get split between a wider pool of arbitrators. Second, please, and this I think the government must do, look at improving the infrastructure for arbitration in the country. What am I referring to? I'm referring to instant transcription services. Now, when you conduct an arbitration in Singapore or in London, however complicated the arbitration is, the trial concludes in 4 days. This is because cross-examination of witnesses is lifetime. As you speak, everything gets recorded and flashes on a screen in front of you. What is the effect? You ask about 600 questions a day. Therefore, however complicated the trial is, in 4 days you complete the trial. There is a day prior to the trial for opening submissions and a day post-trial for closing submissions. Therefore, in 6 days, however complicated the matter is, you complete it. Right? In India, the biggest problem is recording of evidence, because when you ask 100 questions a day, because you have a typist taking it down, you are able to ask 100, maximum 120 questions a day. In a complicated matter, which requires detailed cross-examination, this can spill over 20 hearings. When you're talking about 20 hearings, you're talking about maybe 3 days. Even if you talk about 3 to 4 days in one go, you're talking about 5 separate sittings, which often get spread across 6 months. If you're going to have instant transcription made cheaply available in all Indian arbitrations, trust me, this period of 6 to 7 months that a trial usually takes, and sometimes it takes a lot more, can be reduced to one sitting of 4 days, and that will greatly help make the system efficient. If the good arbitrators in the country can conclude all their hearings in tranches of 6 days, then they become freer on other days because they use up less man time per arbitration. Therefore, this is another way of ensuring that the demand-supply issue in our country is met. So an arbitrator would then possibly be able to handle 3 times the number of arbitrations at a given point of time, because each arbitration would take less time to conclude. Right? Therefore, 2 suggestions are: 1, widen the pool of arbitrators, and 2, bring in instant transcription. Maybe subsidize it. Maybe the government enters into an MOU with 2 or 3 of these providers internationally and tells them that, okay, we will give you mass volume. Please make it available cheaper, because it costs about 3 lakhs a day. If you look at 3 lakhs a day and compare it with the number of day fees that you would save when it comes to both counsel fee and arbitrator fee, 3 lakhs is still not a huge amount, because if you're going to have 5 days of hearing, it's going to be much more than the 3 lakhs. But maybe to provide an incentive, the government initially subsidizes it. Right? Therefore, where are we on quality? Again, I think parties have become more mature about their appointments. You do have reasonable quality, but I think there is still some way to go. And there are steps that can be taken to incentivize this. The second issue is the issue of minimum judicial interference. Honorable Justice Sundar has spoken at length on the scope of Section 34 and how today minimum judicial interference is the norm. And I think it's thanks to judges like Honorable Justice Sundar. I remember one of the first judgments that really set out this principle was his judgment in Govt Associates, which was even prior to Sanyo. But now I think the norm is minimum judicial interference. I think we've come a long way, especially post-2015, in relation to this. But where minimum judicial interference has not really taken off, well, I can't say it's not taken off, it's still better, is in the context of appointments in Section 11. Now, the test was far wider prior to the amendments based on the judgments in SBP versus Patel Engineering and Bogra Polyfabs. Now, the test was legislatively narrowed down by way of introducing 11.6a, which said that the only issue you can look at before appointing an arbitrator is the existence of an arbitration agreement. Now, there have been judgments of the Supreme Court, Duro Felgura and Mayawati Trading, that have strictly interpreted 11.6a and said that the test is narrow. But there have also been judgments like Hyundai Engineering, which have actually gone into issues of arbitrability and accepted matters under Section 11. And Hyundai Engineering is a 3-judge bench of the Supreme Court. Arbitrability could not have been gone into even under the earlier regime prior to 2015 based on the judgment of the division bench of the Supreme Court in Lafarge's case. But what judgments like Hyundai Engineering do, there's one more insurance case, Hyundai Engineering with United India Insurance, and there's one more insurance case. Both of them go into the issue of accepted matters, which should certainly have not been gone into pursuant to 11.6a's introduction. Now, today there is still some confusion simply because Mayawati Trading, which says you can only go into existence of arbitration agreement, is a 3-judge bench. Hyundai Engineering is also a 3-judge bench. Now, which view prevails? So there is still some litigation on this front, and this is an area where there is scope for improvement. But overall, on the issue of minimum judicial interference, I think we've come a long way, and today we are on par with most countries internationally. The third aspect, now one more before I move away from minimum judicial interference, I think we have also we now have also amended Section 2.2 to ensure that Indian courts do not interfere with foreign seated arbitrations except for providing interim relief and for assistance with evidence. And that also has gone a long way in boosting India's image as an arbitration destination. And therefore, so far, where are we? Insofar as the neutrality, we've moved forward, quality, we've moved forward, but both of these, there is still some way to go. Minimum judicial interference, I think we've taken multiple strides forward and things are looking up. But it's important that both of these go hand in hand, because if the quality is not up to the mark, but you have minimum judicial interference, there will be a period where injustice will result. There will be awards that are off the mark, but because of the principles of minimum judicial interference, they cannot be set aside. Right? Therefore, well, there are positive steps, but still some way to go. The third is we require a regime that incentivizes performance and compliance. Well, under the earlier regime prior to 2015, you had the National Aluminium versus Prestige judgment that brought in this concept of what is referred to as automatic stay. Now, what is automatic stay? Now, when an arbitral award is passed, the losing party files an application under Section 34 to challenge the award. Based on National Aluminium versus Press Steel, the award becomes inexecutable till the Section 34 is disposed of. Now, therefore, if the Section 34 was pending for multiple years, there was an automatic stay of the arbitral award, and the successful party would not be able to reap the fruits of its success for multiple years. Now, that has been done away with by incorporating Section 36(2), which legislatively overrules National Aluminium versus Press Steel, and now there is a requirement for seeking stay of an arbitral award, and while seeking stay, courts can impose conditions, and based on some rulings of the Honorable Supreme Court, the usual conditions that are now being imposed are 60% deposit of money and 40% bank guarantee. That is, if there's an award, for 60% of the award, courts are asking parties to deposit, and for the balance 40%, parties are being asked to furnish a bank guarantee. So therefore, and parties can also, the winning party can withdraw the 60% by furnishing a bank guarantee of its own to the tune of that 60%. This is resulting in successful parties seeing the color of the coin early, and that's a great system of incentives that has been brought in both by the amendments and by recent judgments of the Honorable Supreme Court. There is also a very effective cost and interest regime in place, but I must say that cost regimes are not, as in there's a provision now in the statute which incorporates the English provisions on costs, based on which tribunals are supposed to follow the principle of cost follow the event. Therefore, for instance, if the claimant has succeeded in the arbitration, but the claimant has spent 1 crore on the arbitration, the costs, the respondent must be directed to also pay costs to the tune of that 1 crore. Now, in India, granting actual costs have been unheard of. There were some judgments of the Honorable Supreme Court in the context of the CPC, which only said that it must be very reasonable cost, and reasonability was determined based on the local high court rules on what should be an ideal lawyer's fee, etc. But I think what is important to understand is that when you're looking at commercial arbitration, you're looking at complicated construction and infrastructure matters. They are very, very expensive to handle. It requires expert witnesses in some cases, and these experts are not cheap. Lawyers are not cheap. Arbitrators are not cheap. Therefore, at the end of the day, it's very unfair if one party, for no fault of theirs, has to go through with the entire arbitration and bear all these costs. And that's the reason why the amendment was brought in by virtue of the 2015 amendments, providing for the same provisions that are there in England. If you conduct an arbitration in England or in Singapore, in every case, actual costs will be granted. So you have costs running to from 8 to 10 crores of rupees in some of these arbitrations for large commercial matters. Now, I have started seeing a number of some arbitrators who actually sit in international arbitration, grant 50% of actual costs, 70% of actual costs, but it's still not become as prevalent as it should be. The reason why I think it's important to have a realistic cost regime is the losing party must realize that it is because of them that the other party has had to go through all of this. The minute we have a realistic cost regime in place, you will first cut out absolutely frivolous arbitrations where the claimant just claims the sky without having a case. You will also have genuine claimants being compensated for the cost spent by them in pursuing the arbitration. So I think this is the legislative framework is there, but I think practically this needs to be developed a little more before we reach an ideal state. This takes me to the last point, namely the culture of arbitration. Now, I go back to what I stated earlier. We need, that is instant transcription, because instant transcription automatically also brings in a lot more professionalism. As a lawyer, if you have to cross-examine on a particular day, you need to be prepared to ask 500 to 600 questions. Therefore, it involves a lot more preparation. In arbitrations where you're dictating questions, sometimes you just prepare for 80 to 90 questions and then you see how it goes. So instant transcription brings in that additional professionalism. It brings in that efficiency into the system. And I think we must ensure that the culture of once a timeline is fixed for an arbitration, that has to be adhered to. That culture is absolutely crucial for India to develop into a leading seat of arbitration. It's very, very, very rare abroad for a hearing to get cancelled. In India, a lot of arbitrators have become much stricter, but there is still some scope for this, especially when it comes to evening arbitrations that are still sometimes prevalent. Therefore, where are we overall? I think we have certainly taken gigantic strides forward in becoming a leading seat of arbitration, but there is still some course correction that is required, and I'm an eternal optimist. I'm confident that over the next 4 to 5 years, we can reach the destination of becoming an excellent seat of arbitration. Thank you.
Thank you, sir. Thank you. Thanks a lot. Thank you. Your words are very much initiative for the new arbitrators and as well as for the students. There is only more questions are came, but I want to ask only one question from a student. That
Yes.
is Sindhu from 4th year of our college. So she asked about what is the difference between venue and seat. Is there any case law is there or like that? She's asking.
Yeah, between venue and seat, there's actually quite a confusing march of law on this point. I would suggest that the latest judgment that you read is BGS. BGS goes into this concept. Now, let me traditionally, I think some of these are also set out in Honorable Justice Sundar's last slide. Now, let me explain what the concept is. Now, a venue can be any venue for arbitration. That can be based on convenience. So, for instance, if 3 witnesses have to travel, the arbitration may be in Chennai. But if 3 witnesses have to travel from Bombay and there's a sole arbitrator, the arbitrator may say, well, why don't we just have it there for the convenience? So, venue is based on convenience. Along with seat, you have a whole lot of other, you have the entire legal regime of the seat affixing itself to the arbitration. Therefore, you will challenge an arbitral award only at the seat, right? Now, there is some confusion in BGS because section 21E and the judgment in BGS, there is some confusion, but now following the judgment in BGS and the earlier judgment in Indus Mobile, challenge can only be at the seat. So, seat will also determine what is called as curial law, which is the procedural law to determine, say for instance, in an international arbitration, which is with a seat in Singapore, what is the value of an Indian judgment, right? So, if an Indian law issue arises, how would you deal with it? Now, for that, you will have to procedurally look at evidentiary rules in Singapore, which say that so far as Commonwealth countries are concerned, you will have to plead questions of, you'll have to plead judgments as questions of fact, but statute itself can be pleaded as questions of law. So you will then know how do you treat various procedural aspects like evidentiary aspects. And in order to decide this, you will have to first determine what is the seat of arbitration. To decide what is the seat of arbitration, there are multiple tests. The test that today is in vogue, I'm not going into the march of law because I will be speaking for the next 45 minutes on this. The test that is today in force is if there is nothing else that is mentioned, only a venue is mentioned, seat would be the venue. But if there is something else to the contrary mentioned in the clause that gives an indication to the contrary, then seat would be different.
Thank you, sir. Thank you. Thanks for the compliment speech and replying answer for the question. Now,